Well, from water and grazing issues to bankruptcy and estate planning, there's often a number of legal issues in agriculture at any given point. Roger McEowen with the Washburn School of Law joins us now to review some recent ag cases. As always, Roger, a pleasure to have you here. We first want to look at a case that involves water drainage. And tell us about this and who's responsible.
Yeah, good to be with you, Suzanne. The water drainage issue is actually a big issue, primarily in the eastern two-thirds of the United States and predominantly in the eastern third where water is more plentiful. And the basic rule coming out of this case from Iowa is that a landowner can do basically whatever you want to do with respect to the drainage of excess surface water, so long as you don't increase the flow onto an adjacent property owner. So you can drain into a natural drainway, into a swale, into a ditch. You can cast more water onto the neighbor as long as it doesn't cause any damage. That's the general rule in most states. If it does cause damage, then you're going to be responsible for it. That's the rule that came out of this case.
What about another case? It focuses on mortgage interest deduction. Give us a little background on this.
Yeah, well, if you're going to claim a mortgage interest deduction, you better have an ownership interest in the home. And they the parties in this case claimed a mortgage interest deduction for a tax year associated with the home that his brother purchased for about $1.5 million back in 2005. There was another guest house that was also purchased, and the taxpayer involved in this case actually had that quitclaim deeded to himself. But there was never any evidence that he lived there. He didn't make any payments on the loan. And so the IRS said, well, you can't claim a mortgage interest deduction because there's really no ownership interest that you have in it. And the tax court agreed with that.
That makes sense. Well, another update, the charitable deduction case going on trial has numerous issues. Talk about what we can learn from this case.
Yeah, charitable deductions, IRS watches pretty closely, particularly if they're big and particularly if they involve conservation easement deductions for a donation of a permanent conservation easement to a land trust, for example. That wasn't this case, but what this case involved was a very substantial multi-million-dollar claim charitable deduction. And what comes out of this is there are heightened requirements that apply to substantiate that deduction, and you must have an appraisal. That did not happen in this case, plus the person that was promoting this as part of an overall estate planning package was in trouble with the Department of Justice and ended up being convicted.
Wow, a lot of money on the line on that, too. And overall, Roger, what's the takeaway from all of these cases? What should people really know beforehand?
Well, there's really a lot of education that's involved with respect to all of these issues. In fact, I just spoke earlier this morning on drainage issues in Indiana, where I'm at right now, and I get a lot of questions with respect to what can I do with respect to surface water. But the law is so technical on so many points, and it impacts farmers and ranchers in so many ways. It's almost endless amount of education that one could sit through and still not learn everything.
Right. I know you do all the work. We are so happy to have you here. And you go into great length online. Where can people go to find out more?
My website is washburnlaw.edu/WALTR, and then my blog where I write a lot of these pieces up at can be found. There's a link on the left-hand side of my homepage.
Is that the lawprofessors.typepad.com?
Yep, the Law Professors Blog Network.
All right. Thank you so much, Roger. Roger McEowen with the Washburn School of Law. Always great information.